A mistrial has just been declared in the NA shooting trial up in Flagstaff. We've been following this case very closely, and of course, you're getting the best breaking news coverage as we continue to monitor these latest developments coming out of Flagstaff this afternoon.
Yeah, Stephen Jones, now 20 years old. He's a free young man today. He will head back home, and this all resumes possibly in August. But he was just 18. It was the middle of a fall semester up at NAU, middle of the night confrontation with some students. He ended up pulling a gun out of his car and firing at those students, killing one, injuring three others. Again, the jury could not come to a decision on whether he is guilty or not guilty of first-degree murder. And joining us is James Goodnow with Fenimore Craig, who has been following this case. You have a history in criminal law. You're also a trial attorney. You weren't surprised after you knew the events of today, but overall, how surprising is this? Because it's not common to have a hung jury.
It's not common to have a hung jury. I would say this is surprising in the sense that typically the jurors would push through, and ultimately you would have that foreperson who would come to the table and say, all right, folks, we need to have a decision here. That didn't happen. But if you step back from this and look at it, this is a messy case. When you talk about it just in day-to-day life, people have different opinions on this case. On the one hand, they say, well, boy, those fraternity kids had this coming. On the other, you say, well, but boy, you know, to have a gun and to take it out and to go to your car and then come back, that's just going too far. So this is a case that lives in the gray area.
And the law says if you fear for your life or you fear for the lives of others, you are justified firing. And that was part of the argument here because he also had friends involved in this.
That's exactly right. So the law says that in order for you to use deadly force, you need to believe that it's necessary, that there's an imminent threat to yourself or others, and that there's no other alternative. So here we know Stephen Jones had in fact left the scene, went to his car where he was at a point of safety. Now he's going to say, and he did in fact testify that, no, I thought that the fraternity guys were coming after me. Right. But then he said, I wanted to go back to protect my friends. Well, if he had a legitimate belief that his friends were in danger and that their lives were on the line, he could use that deadly force. But if I'm a juror, I come back and say, well, wait a second now. These fraternity guys didn't have guns, they didn't have knives, they had their fists. Is that really enough for you to believe that their lives were in danger? This is the question that these jurors were wrestling with, and that's why we have a hung jury here.
James, I find it really interesting when Judge Slayton declared a mistrial. He addressed the jury directly and he said, you did not fail. I found that to be interesting, and as you mentioned, these are 7 women, 7 men, 2 alternates wrestling with this decision because it is a very gray area. And so now I'm just wondering, they're going to come back home. Certainly we may hear some of their accounts as to what occurred during this trial. But let me ask you this, separately from the jury, what can this potentially do for the prosecution and the defense, in your opinion, as an attorney? Did they fail in some way, shape, or form by not getting a verdict from the jury?
Yes. This is really viewed as what I would call a stalemate. When you're a prosecutor, your goal is to get a conviction. And as we talked about earlier, with 90% of cases ending in a conviction, if you don't get that, you feel disappointed and like you didn't deliver. Now, on the other hand, this isn't a win for the defense. A win is getting an acquittal. So this means now everyone has to go back to square one and start again. Now, there are lessons to be drawn on both sides. You know that the defense lawyers and prosecutors will come back and recalibrate their case. But I think in the case of the prosecution in particular, they are going to think very carefully about how far they want to push this. We know that in closing arguments, prosecutors came in and put up a PowerPoint saying, here are all the ways that Stephen Jones was lying. He was in fact not truthful with you. The problem, though, is that didn't really fit with what we saw of him on the stand. He came across as a credible witness. He came across as someone who was willing to go in front of the jury. In criminal cases, most defendants do not take the stand. Lawyers instruct their clients not to take the stand. And when you do have someone who's willing to do that, it sends a message to the jurors that this is someone who is really convicted in their beliefs about their innocence.
And ultimately, emotions probably play a big role in the jurors' decision, even though they have to look at all the facts. It largely comes down to a matter of trust in his word. How does he come off? What's their feeling about his demeanor? And you felt like his testimony was strong.
I think it was strong. He was appropriate, he was measured, he was articulate, and I think that surprised a lot of people here. But I think there's a bigger point that you just raised. When we have those 12 jurors in the deliberation room, these are human beings. These are mothers and fathers and grandparents who understand that this is a young man, 20 years old, who has his entire life ahead of him. Is that in the jury instructions? No, it's not. But is it a real factor that practically can affect the outcome of a case like this? Yeah, it is. And so you know those sorts of sentiments were certainly playing into the outcome we saw today.
Well, as you said, again, here in Arizona, you know, you go into territories of regarding the Second Amendment, but then you also have, of course, self-defense, etc. We were watching in that video just seconds ago, that body cam video that was released by police a few months ago. And I just think that that video in particular really helps to shed a light into what those chaotic moments were right after the shooting took place. And you see there Stephen Jones bloodied, crying, asking how the other students are doing. And again, it's a very polarizing case. Which side are you on? Was he really acting in self-defense, or did he really premeditate the murder of the student and injure the others? It's such a gray area, don't you think?
It's really a little bit of both. If you had this exact same case and you took out one fact, and that was the fact that Stephen Jones goes to his vehicle, walks 90 feet away from where the mob is that he claims, where the violence is taking place, if that's removed and instead everyone is right there the entire time, I think you end up with an acquittal here. But it's the fact that he chose to walk away. He got to a point of safety. And even if he couldn't get into his car because he says he was flustered and he couldn't find his key, he could have run and he could have gone away. So this is really a case of fight or flight, but they've come together now because you had the flight then fight. And I think that just perplexed jurors and they didn't know what to make of that.
And it's interesting, when this news came down the morning of the shooting, we heard of a shooter on campus wounding several students unarmed. And immediately, I think the public sentiment was, this guy's a bad guy, and, you know, he lost it, right? And then as the details come out, the facts come out, now the trial's played out. Does this say something, too, about Arizona law? Because just a few years ago, lawmakers actually made it more difficult for the prosecution to prove that a shooter is not justified.
That's exactly right. Arizona is one of several states in the country that has what's called the Stand Your Ground laws. And what that means is if you are being threatened with violence and you believe that your life is on the line, you don't have a duty, an obligation to retreat, to run away. So here, that's not the situation we're dealing with, of course, though. We have someone who actually gained ground.
He went back to the trouble,
That's
which
right.
I think is what a lot of people had a problem with.
That's right. It's not standing your ground. It's being aggressive here. And I think that really has troubled people looking at this case, pundits, commentators, and clearly the jury.
It's possible there was just one holdout juror here, too, right, at the end of the day?
Absolutely. It's possible that you have one person who says, I'm not going to give on this. I believe either conviction is appropriate or acquittal. And that person would resist all of the persuasion that takes place. You think back to the movie and book 12 Angry Men, where you're trying to flip that juror. And I will tell you, in most cases, those jurors do get flipped. So if it ends out being one holdout, that's someone who had a very strongly held belief.
And we saw there just in the last few days, the jury going back to the judge, asking more questions, and some say that was indicative that this could potentially end up in a mistrial. Attorney James Good, don't go anywhere just yet. Thank you for joining us. We want to go ahead and once again play for you what Judge Slayton said in the moments when there was a mistrial declared earlier this afternoon.
Been informed that the jury has indicated that you do not feel that additional deliberations or assistance will help you in reaching a verdict. Is this correct?
That's correct.
All right. And I also want to make sure that it's placed on the record that after we gave you the instruction, you in fact did go back and review the evidence, asked for the exhibits back, and did spend a few hours going back over it. Is that correct? All right. Thank you, sir. This court is therefore going to declare a mistrial in this case. I'd ask the attorneys to waive the 60-day rule.